Hello, and welcome to the American Probation and Parole Association's webinar session on alternatives to incarceration in Indian Country. My name is Kim Cobb, and I'm a research associate with APPA, and I'm pleased to welcome you to today's session. This webinar is being provided to you today in partnership with the Bureau of Justice Assistance and the Office of Juvenile Justice and Delinquency Prevention. Today's presentation will be recorded and posted to the APPA website along with a resource sheet listing available BJA and OJJDP resources available regarding alternatives. I'd like to go over a few quick items before we get started with today's discussion. All participants will remain muted for today's discussion to avoid any background noise. However, we may ask you a few questions throughout the presentation using features on GoToWebinar such as polling. When these polling questions come up, just please click on the appropriate response on your screen. So let's start with a sample question. So please let us know if you primarily work with adults, juveniles, or both. We'll wait just a few minutes for all the votes to come in. Okay. Looks like we have about 53% that reported that they work with both adults and juveniles. So that's how you use the polling questions. Also, if you have a question for our presenters during today's session, you can submit that via the chat feature. Simply type in your question and we will reserve some time at the end of the presentation today to answer any questions that you may have. Also, if you're having any technical difficulties during today's presentation, please chat that in as well and we will have somebody monitoring that. With that, let's move into an overview of today's presentation. So today's objectives are to define what is meant by alternatives to incarceration and discuss the importance of having ATIs along the criminal justice continuum. We will also discover no-cost, low-cost, and higher-cost examples of ATIs. We will discuss strategies for and challenges of implementing ATIs. And we are also glad to have on the line 4 practitioners from the field that are going to be discussing the different ways that they have implemented ATIs in their community. Before we begin, it's important to define what we're talking about when we say alternatives to incarceration. While there are a variety of definitions available in the literature, essentially ATIs are responses to crime that do not involve secure confinement. ATIs can be accessed either instead of confinement in a secure facility or as a service available upon re-entry. You may sometimes also hear it referred to as correctional options. Alternatives to incarceration are typically talked about being important on the front end of the system. In other words, providing opportunities for offenders to seek treatment and undergo community supervision instead of going to jail. It's important to note that alternatives can and should also be in place at the back end of incarceration. We all know that eventually offenders come home to the community and it's important to have things in place for them to reintegrate back. So why is it important to consider ATIs for your community? First of all, it's important to look at who is actually in tribal detention facilities. According to the Arizona Attorney General, 99% of all crimes in Indian Country are attributed either directly or indirectly to alcohol and substance abuse. It's essential that tribal justice agencies reserve the limited detention space available for more serious offenders. Additionally, community supervision is new for most tribal justice agencies, and many do not have systems in place to deal with technical violations through administrative sanctions or through graduated responses. So in many cases, detention is their only response to noncompliance with community supervision. This doesn't mean to minimize the types of offenses being committed in Indian country and processed through many tribal courts. Indian country justice systems are dealing with very serious offenders, such as domestic violence offenders, sex offenders, and gang offenders. The point here is that a good percentage of individuals in many tribal detention facilities are substance abusing nonviolent offenders that, if alternatives existed, could just as effectively be supervised in the community. The Tribal Justice Plan reiterates that alternatives rather than incarceration is the desire of many tribal communities. Through the various ways that tribes contributed to this long-term detention plan, through consultations and surveys, many tribes express the feeling that it's not their intention to put their people in correctional facilities if they can safely be supervised in the community. Many tribes that we have talked with who lack facilities in their community state that it's difficult to first find facilities that will enter into cooperative agreements with them, and second, to transport those requiring even temporary detainment to facilities that are oftentimes very far away. For an individual requiring only overnight or weekend detainment, that can be very cost prohibitive. If you look at the evolution of the Correctional Facilities on Tribal Land project, this funding stream started out as the construction of secure facilities only. It is now transformed into an opportunity for tribes to build multi-purpose justice systems where they are allowed to incorporate space for alternatives to incarceration or correctional options. So let's take a look at a variety of the different kinds of ATIs that you can implement in your community. The key is to identify ones that work for your specific community and adapt them to fit their needs. The ones listed here, I say, are no cost virtually because everything you do has a cost associated with it, but these can be implemented with very little funding. The first is a community service program. This requires engaging the community and service providers and businesses in your community. It's important to use a strength-based approach to make community service assignments by identifying strengths or interests that an individual has and try to find a placement to build upon that. Chances are, if they're interested in their placement and can learn something from them, they will be more likely to be engaged. Many tribes are looking to experiment with or return to the use of elder panels. We have a speaker on the call today who's going to be talking about how they use these elder panels in their community. Finally, work and school release programs is a combination of detention and release time. It holds the person accountable, but also lets them remain productive providers for their family, allowing them to remain active in their work and school. This would be more appropriate for jurisdictions that have a facility or close access to a facility where you can work with detention staff to make this work. Some low-cost examples of ATIs include home detention or curfew. This is a relatively low-cost alternative. There are many technologies available to help with this type of supervision, and many programs weave the fees for participation into probation fees or fines. You can also use this without technology, but it often requires law enforcement or probation doing periodic check-ins to make sure that the person is abiding by these terms. Another alternative is mediation or dispute resolution. These can be operated in a variety of fashions. Many use them as sentencing circles or elder panels. Some judges will actually volunteer their time, or often a community member can be trained to operatively lead these meetings. Many programs often choose to look at restorative justice philosophies. The premise behind these is that a crime is an offense against a human relationship and that victims in the community are essential to the justice process. Many tribes also look to the use of specialty courts, such as healing to wellness courts, drug courts, domestic violence courts. These often operate on a specialized docket and have case management that goes along with that. The use of intermediate sentences is where a person is sentenced to a number of days to serve in detention but does not serve it consecutively. So, for example, a person can be sentenced to so many days and serve that out on weekends so that they are home with their family or attending Milken School Monday through Friday, and then they may report to serve their time on weekends, say from Friday evening to early Monday morning. Shock incarceration or probation is another form of ATI. This is where a person is usually sentenced to a period of detainment less than 30 days and then to a period of probation. And then finally, diversion programs. There's many types of diversion programs available, such as drug courts and teen courts. All of these have found great success in keeping mostly juveniles out of the system. Upon completion, the charges are typically dismissed. So these are some higher cost options or alternatives to incarceration. The first one is a day reporting center or a day treatment program. This is where offenders are required to report to the centers, but then often return to their homes and sleep at night. There's extreme diversity in day reporting centers, how they operate, the types of services they provide, the types of clients they accept. Many of them will provide, say if you have somebody that is unemployed and is having trouble finding employment, they can be sentenced to report to the day treatment program or the day reporting center, and the probation officer is able to keep track of them while they get services such as maybe taking GED classes, receiving treatment, doing some employment searches, receiving group and individual counseling. Another high-cost option is electronic monitoring. We have somebody on the phone that's going to talk about that a little later, so I'm going to reserve his time for that. Halfway houses or group homes. These are facilities that are often used in transition when you're transitioning a person back to the community after a period of confinement. They often provide services as well, such as life skills, family reunification, counseling, and treatment. And then finally, probation and intensive supervision programs. Probation is one of the oldest types of alternative to incarceration. A person placed on probation is supervised in the community where they can remain connected to their families. They can remain productive people for their community and for their family. And they often receive services that they might not be able to get in a confined facility. So let's do another quick poll here and find out. Let me launch this here. What are some of the challenges that you may encounter in implementing alternatives to incarceration in your community? So what would be your top 3 challenges, if you could go ahead and vote now? We'll give people just a few minutes here to make their selections. Okay. So it looks like about 77% indicate that it's a lack of funding, followed by lack of infrastructure, and then lack of staffing or personnel to oversee. So thank you for participating in that poll. So some of the challenges that we had for you to vote on are on the screen now. Obviously, cost is always a major hurdle for people to go through when implementing new programs in their community. Hopefully through this webinar, you have gained and will gain some examples of a different variety of low cost, no cost, and higher cost options that you can implement. But keep in mind that what's presented here today is not exhaustive. ATIs can allow you to create your own program. Another barrier that we often hear about is a lack of information about the different types of alternatives that are out there. And webinars such as this are good to get information out about what kind of things you can implement in your community. Lack of community and leadership support is sometimes cited as a reason. Oftentimes community and leaders want to see individuals being held accountable for their actions and question the use of ATIs as a response to crime. However, if you talk to many offenders, they'll tell you that being sentenced to some type of alternative is often more work than being sentenced to incarceration. So in many ways they are being held more accountable through processing through an ATI. Staffing and personnel is often an issue. Depending on the type of alternative you're implementing, new staff may have to be hired or duties may have to be added to existing personnel. And then obviously lack of infrastructure for things such as halfway houses, transitional living, or day reporting can be a challenge. At the end of this webinar, we're going to provide you with some resources from BJA and OJJDP that may be able to help with that. And then finally, net widening. This often refers to when you have programs in place to deal with low-risk offenders that maybe if you didn't have the program in place, they probably wouldn't be handled through the system anymore. And so that's something to be careful of, too, when you're looking at your policies and programs for implementing an ATI. Real quickly, I'm going to go through, get my screen here to go. Okay. Some benefits to implementing ATIs in your community. Obviously, it allows for you to have some tailored sentencing options. This allows the court to tailor sentences to each individual's needs and circumstances as recommended by evidence-based practices. Cost savings, it costs about $26,000 a year to incarcerate a person, whereas if you look at some of these alternatives, drug court is anywhere from $1,500 to $5,000 a year. Probation is $5,000 a year. Electronic monitoring can range from $2,000 to $6,000 per year. And so even though on paper these costs may seem expensive, in the long run it's still cheaper than incarcerating somebody. Public safety, ATIs often help individuals address the underlying reasons for their criminal behavior, and it allows them to receive the treatment that they need to keep them from cycling back through the system. It's consistent with tribal attitudes. As we stated earlier, most tribes that participated in consultations insisted that they were not, that incarceration was not a desired response to crime, and so they were looking for more alternatives for their community. And as stated before, it allows an individual response to crime and behavior. In assigning individuals to alternatives, you will need to make sure that you're paying attention to their risk, need, and responsivity factors, and how having a variety of options for judges to sentence them to allows them to be more responsive to those needs. So I'm now going to turn the webinar over to Andrew Cannon, who is going to talk about a elder program that his community is using. So, Andy?
Good afternoon, Kim. Good afternoon, everybody. My name is Andrew Cannon. I'm the PTI Director, the Pretrial Intervention Director for the Mashantucket Tribal Court in Connecticut. Prior to that, I was a probation officer for the state of Connecticut and a chief probation officer for 21 years. So some of my experiences overlapped into the tribal court, and I brought some of that with me, which I have found to be beneficial, and but also has been a learning curve for me as well. The PTI program was derived in November of '93, shortly after the Mashantucket tribe established the tribal court. And they created this pretrial intervention program to balance the punishment of criminal offenders and the protection of the community to prevent further criminal activity and behavior. They did that also to provide a source for the individual that would protect their criminal record, so they would not need to report any convictions on their record if they successfully completed the program. The purpose of the program is basically threefold, and they all intertwine together. It allows the court to avoid ordinary prosecution through early intervention. It provides a meaningful tribal community participation in the criminal justice system, and it provides an alternative to prosecution. By avoiding ordinary prosecution through early intervention, I find that our timeline is very conservative, unlike prosecution in the state courts. One of the frustrations for me over the years was that a case starting from beginning to end, meaning from the time of advisement of rights through some form of disposition, so oftentimes took several months, anywhere from 4 to 6 months. Here, through the tribal court, we can have a case presented in very short time, and if the person is eligible, could actually be placed in the PTI program within 6 weeks. So you can see the drastic difference between the tribal court and the state courts. Through the early intervention, we can also identify the needs and address those much sooner than through the normal progression in court. Once somebody has been identified as possibly being eligible for the PTI program, the process is streamlined considerably, and it basically entails convening the tribal elders together. 3 tribal elders would meet with me and the offender, and we would discuss the case the person's culpability and desire to make some significant changes. With that said, as I said earlier, typically we can have the case back before a judge within 6 weeks, who would then confer sentence and put the person officially into the PTI program. I've come to rely heavily on the utilization of the tribal elders, as they bring valuable resources of wisdom, tradition, and culture, as well as the transmission of knowledge about the tribe. Although I grew up very close by the Mashantucket Reservation, I was not familiar with all of the inner workings and the tight-knit community here. I've been here for 5 years, and I'm still learning all the variety of families and some of the networking. So I rely heavily on the tribal elders, not just the 3 that participate with the PTI Commission, but also on others as well, to impart much of their knowledge and wisdom on the workings of the tribe. We also utilize the Indian Health Services here, and again, working in the past with the state, oftentimes there were time constraints and over budgeting and not enough resources. I found that the resources here have been much more helpful, especially when you have the tribal elders that are making phone calls if they need to, in order to streamline the process and get somebody placed into adequate programming. And as I said, also based on the risk and needs, the Commission will, when they meet with the offender, we do mete out an appropriate disposition, taking into account their risks and needs, and giving them the appropriate dosage for treatment, which we, again, refer out to the Indian Health Services. One thing that's important when we convene with the offender is the person must be amenable to the conditions. We don't just simply sit down and say, well, based on the offense, or based on the victim's wishes, or based on the seriousness of the charges, this is what you need to do, as is typical in regular courts. We really take the opportunity to sit down and talk with the offender, find out where they're coming from, discuss their family, discuss their needs, and then we try to do adequate placement of conditions upon them. The offender actually participates in the case planning with the elders, and in fact will sign off on a written document that they initiate and sign off on, agreeing that they plan to work on those conditions in the case plan. So they identify the problems and possible solutions, as well as any issues that may block those solutions, and we work to try to overcome and adapt to those. Several conditions that we frequently use are drug and alcohol abuse, evaluation and treatment, community service for the direct benefit of the tribe, or I usually try to make it more specific to a needy tribal elder. Also reasonable restitution, and any other rehabilitative directive that's consistent with the crime committed and of the needs of the offender. The program lasts no more than 1 year, and more often than not, we will place them anywhere from 3 months up to 6 months. But after 1 year, we return the case to court, and one of the following dispositions is instituted. Either the complaint is dismissed with a successful completion, or we further postpone it for no more than 1 more additional year. The tribal law doesn't allow for an extension, and that's only under extraordinary circumstances where the offender just simply could not complete all of their conditions. The third is a further order to prosecute the case back under the regular docket. Once a person is eligible for the PTI program, they're removed from the criminal docket and placed on the civil docket, thus protecting the criminal case. But if they are uncooperative, the case is then returned back to the regular docket and prosecution continues. One of the key benefits I found of the PTI program is that it remains confidential from the moment the applicant completes the application. As I said, the case is removed from the criminal docket, and everything from the disposition to discussions and outcomes are withheld and may not be used against the defendant should there be a negative outcome such as an unsuccessful completion. So any comments that the offender has made to me or to the elders when we've held our confidential meetings cannot be released to the court at a trial. I would actually be withdrawn from the court. Questions about eligibility. In general, we do consider the nature of the offense. It should not be it should be for a nonviolent crime, a victimless crime, or for minor offenses. We do take into consideration the facts of the case and the motivation and age of the defendant. They must be 18 years or older. And again, the motivation is how much of a desire do they have to stop the negative behavior and be a more pro-social, active member of the tribe. If there is a victim, consultation with the victim is required to make sure that they're aware of what we plan to do and if they are on board with that. Also, the rehabilitative services, we need to consider what is available, particularly through the Indian Health Services, and if they aren't available, we need to look outside and outsource our cases to available resources within the state. In addition, there's other relevant circumstances. For instance, the offense must be committed on the tribal lands. Our jurisdiction lies completely within the tribal court. We do not receive referrals from the state court or from outside sources. Minor offenses such as animal control laws, health codes, motor vehicle, or similar violations or infractions are not eligible, as they could be taken care of with a fine or a suspended sentence without probation. We also consider prior record of conviction. This type of program is typically geared towards your first-time offenders, although prior convictions may be considered if they were minor and if the offender meets all other criteria. If they are currently on probation, either with the tribe or through the state or federal probation, we would only grant the PTI program upon consultation of the supervising officer and obviously with the permission of the court. I have, since I have been here with the tribe in Mashantucket for the past 5 years, we've had about 25 people referred during that time, and all but one have been successful. So I'm very pleased with the program and how it's transpired here. And it is enlightening that I am able to spend more time with the people. It's important that we bring in the elders and the families to provide some assistance, something you don't typically get in the outside courts. So that will wrap up my presentation, and it's my pleasure to introduce Richard Hart, who will discuss the electronic monitoring program. Thank you.
Good afternoon, everybody. Welcome to the presentation. So, my name is Richard Hart, and I am a Special Projects Officer and also a great instructor for the Lummi Nation Police Department. I've been in law enforcement for about 7 years, and I'm currently involved with our high-risk GPS management program. And I am tasked with sort of bridging the gap between court and probation and law enforcement, and also our other programs such as restorative justice and behavioral health, in order to try and further our program to not only save money for the tribe, but also to strengthen our community relationships and work on better interactions with the community. So I'd like to start by talking about some of the alternatives that we currently use. And if you look at the slide, so most of you probably are already familiar with a lot of these types of programs. We have drug court, we have reentry court, we do deferred sentencing with plea deals, and we eliminate jail time and extend probation. But what we found is that in addition to legal alternatives, we needed something to complement the alternative. So we needed something where we could come in and, from a law enforcement perspective, help enforce some of those deferments that are handed down. So what we looked at was probation's EHM and GPS monitoring program, and then we also looked at a high-risk GPS monitoring program where a police officer, such as myself, would be running and monitoring the program. And what we have found is that we have a higher success rate and completion rate when a police officer can physically come to your home and make contact with you for your entire sentence, albeit it could be 60, 90. I even have people that have been on my plan for as long as a year. And the goal of the plan is to build people back up slowly after being released from jail or even while still on probation. And I can work with their probation officer to offer a little bit more stringent monitoring program. Our GPS system allows gradual reintroduction of offenders into an environment that will help them succeed, and it offers support if they start to slip backward. So we don't just let people out and then say, oh, you're good to go, you finished your 30-day sentence, and now you're on your own. So we also have future plans to incorporate a transitional home, and it's going to utilize the GPS program. And the transitional Longhouse program is intended to be an alternative to incarceration that will allow participants to attend an intense outpatient treatment and counseling program. During the time that they're in a transitional home and on the GPS system, they'll be able to attend school, they'll be able to go to vocational technical schools, receive counseling from employment and training. So in addition to the GPS, we're able to add all these additional layers to build the program up to get a higher success rate. Some of the intangible benefits that we have are obviously our community relationships. So we're able to build the relationships with community members as far as police are concerned. And we're able to build relationships with family members, because far too often police officers are considered to be the bad guy. So by doing this program, I've found that we're able to build a relationship with our offender, their family, and show them that we not only care about their safety in the beginning, because we're the guys that picked them up and arrested them, but we also care about their success and completing their full sentence. So it makes a big difference. In this situation, police get to have more positive influence and interaction with all the offenders. So again, it's not just an arrest and then move on to the next arrest. We're following up with our offenders, we're talking to them, we're learning about their problems, learning what we can do to help them to succeed. The officers become mentors. That's an important one. From a law enforcement perspective, you end up with a lot of officers that arrest, move on, write your report, write your report. You don't end up with officers that go back and say, hey man, I know I arrested you last week, but how's it going this week? So by becoming a mentor and working with an offender, I get a positive interaction with that offender so that he feels he can trust me when he gets into a situation where he might get in trouble, or she. And I found that by becoming a mentor, I get more positive interaction, again, with community and family members. And I've even got people that call me after they've completed my program. Hey, Officer Hart, can you help me out? I need some help with this. So it works out really well. The continuity of service is important. We show the community that we care about safety, but we're also a part of the community, and we want the community to be better. As it was shown earlier, a high percentage of the offenders have alcohol or drug problems. So by doing this, we're able to learn about those problems and help them steer clear. So tangible benefits that come from the program, again, just as important. Reduction in jail population. So for us, we're in Whatcom County, Washington, and about 2% of our tribal members are incarcerated, either in tribal jail, county jail, or state prison. So 2% of our entire tribal population at all times is incarcerated. That's our current statistic. So by doing this, we're able to reduce that. Nobody wants to see people spend a lot of time in jail unless, obviously, the crime meets that offense. So we like to reduce the population. The community safety is another important aspect. So again, we're able to increase that interaction with our officers. So next time I come across this offender and I've built that relationship with them, instead of a fight, maybe we can talk it out. Maybe we can figure something else out. Because he already has that interaction with me. I'm not just the mean old officer that marched up to his house to arrest him. So reduction in recidivism. So after completing the GPS program, we're seeing less reoccurrence and the offenders continue to attend their meetings, continue to go to treatment, they continue to stay on the straight and narrow path that we've set out for them. My current success rate is 87%. That's in 2013. So when you look at some other programs as far as GPS and EHM are concerned, you don't necessarily see success rates that high, and a lot of it is due to the lack of monitoring. With the police program, the biggest difference between my EHM program and, say, a probation department's EHM is I can arrest people on the spot. So if you violate the terms of your contract for GPS, you can immediately be arrested and taken to jail. It's not, oh, I'm going to file this paperwork with the court, and maybe 2 weeks from now we may have a warrant for you. We're not sure. So it's a very quick So the big one that a lot of people, I noticed we already talked a little bit about cost and lack of funding. So the next slide will show you that there's a significant cost savings involved here. So I took a few liberties, but this is on the basic cost analysis for us. You know, in 2011 with 3 offenders, and this is assuming that you're in jail for 365 days a year. So you can see that you're looking at about $70,000 worth of jail expense, but the actual cost of having that person on GPS or EHM for us was around $20,000, significant savings. And then again in 2012, we only added 1 more person, and now we are in 2013, where you're looking at 8 offenders that are going to be on GPS versus jail. So the cost to have those people in jail around $220,000, whereas our overall cost out of pocket to put them on GPS is going to be around around $65,000. And then again, 2014, you can see there's quite a difference. If we were able to double the program and add 16 people total to the GPS program, instead of spending $450,000 on jail, we're going to spend just over $50,000 to have people on EHM. So the savings is there, the community relationships are there, and we're able to really establish a much better program just because the police department manages the program versus probation and the courts. And so I can bridge those gaps and make the program even more of a success. So I hope that everything I've told you, if you have any questions, feel free to let me know, or I believe we're going to have the email addresses available. But if you have any questions from me, feel free to email me, and I'd be happy to share anything. So that's all I have for my end of the presentation, and I will hand it off to Stephanie Autumn.
Good afternoon, everyone. I'm waiting for my slides to show up on the screen, and while they're changing, they're there. Before I begin the conversation, or to give you the backdrop to alternatives to incarceration and what it could possibly look like for tribal youth in your community, I want to share a little bit of a story or a part of a meeting with you that took place about 2.5 weeks ago in Washington, D.C. OJJDP sponsored a meeting for their tribal juvenile detention and reentry grantees and other tribal juvenile detention center staff and administration, and it was a one-day meeting around alternatives to detention. During the course of the day, I think there was about 11 detention centers represented at that meeting. During the course of the one-day meeting, one of the facilitators posed these 2 questions to the group. The first question was, how many of you in the room at your detention facilities in your communities are utilizing alternatives to incarceration? Nobody raised their hand. The second question was, how many of you in your communities, in your facilities, in your youth-serving agencies are planning to implement an alternative to incarceration for your tribal youth? Again, nobody raised their hand. I think that this response reflects really clearly for us in Indian country the depth and the breadth of work that lies ahead of us in creating alternatives to incarceration for our tribal youth. In looking at a backdrop for alternatives to incarceration from tribal youth, it's a little different than for adults. For all of us that work in youth-serving programs or tribal youth programs or in tribal youth detention centers, we know our young people need to be in their homes, they need to be in their communities, they need to be in their schools, they need to be thriving and succeeding in order to realize their full potential as that future. We always say our youth are the future for the next 7th generation. So there is a lot of work ahead of us regarding juvenile detention reform and improving outcomes for our young people that come in contact with the juvenile justice system. So in Indian country, in working with juveniles involved in the juvenile justice system and looking at alternatives, we know there's not one moccasin fits all. We know that we should be looking at, when we're developing alternatives to incarceration, we want to see an increase of prevention and intervention strategies for our young people. We want to see better utilization and research around asset-based and holistic youth-centered approaches. We know that our young people need family involvement, they need community involvement, and we need to start looking at, instead of the offense and the deficit of the person, is that the young person is to look at them, what's working for that young person, what's working in the family, what can we build on in terms of to be able to help this young person make better decisions for themselves. Part of what we need to look at in developing alternatives to incarceration for our young people is we need to make sure that we're increasing the strategies to have better outcomes with family involvement and community support. Oftentimes we put the burden on the family to come to the meetings knowing that our family don't have transportation or the monetary support to get them where we're expecting them to be. We know that a lot of our family, while we may be informed individuals in our communities, our families and our young people aren't aware of all of the support and resources. We need to do a better job in designing our alternatives to incarceration, making sure that our families know what's available to help deter some of the negative behavior that has led to the offense or the contact with the juvenile justice system. Oftentimes we wait to the very end to expose our young people to cultural teachings and elder involvement. We really need to rethink how are we engaging our cultural programs, our cultural teaching, those elders at the very beginning of contact with the juvenile justice system. In looking at alternatives to incarceration for young people, we have to step back a little bit in terms of saying detention and incarceration are alternatives. Part of what we always say in our communities is that we want to create health and wellness, that we want safe communities. So it will be really important when we look at the alternatives to incarceration that we're designing, that they're decreasing the reliance on law enforcement and that we're increasing the non-secure options for tribal youth, for our minor and low-level offenses, and only in extreme cases that our young people need incarceration. We should be designing programs where our young people can get the services and the treatment and the support and resources that they need outside of the community and not inside a detention center. If we are able to create comprehensive alternatives to incarceration, we will create system-wide changes within our youth-serving agencies, our tribal court, law enforcement, and most importantly, our community. Next slide, please. Part of, for those of us that have been trained about the Western model of arrest, detainment, and arrest, prosecution, detainment, and possible incarceration, we really have to do a paradigm shift because when we're thinking about alternatives to incarceration, we have to focus more on the pre-adjudicated services and programs that we need to expand. We need to really comprehensively look at our screening tools, our assessment tools, our referral systems, where our young people are they being appropriately placed at the different risk levels. Part of what we have to examine in terms of thinking of developing alternatives to incarceration in our communities, will what we are designing really change the pattern of detention? Will it make a difference? Will it save those tribal program dollars? You heard earlier in the presentation the cost of detainment. We know in Indian country that we don't have enough dollars for education. Middle school, high school, that's where we're losing our children. We really need to spend dollars that would be for detainment and be able to put those dollars into educational services. We don't have enough dollars for cultural and recreational activities. So we really need to think about in designing our alternatives to incarceration, will they do this, improve public safety, and in the end, decrease juvenile incarceration? Next slide, please. I always recommend to any of our grantees that are looking at designing alternatives to incarceration, the very first step is doing an environmental scan. I know sometimes that sounds really scary, but it's really easy. It's just about collecting data, examining data, looking where the gaps are, looking at what your resources are, and then taking that data from your environmental scan to develop a strategic plan. In this case, to develop alternatives to incarceration. So you would collect things like your arrest rates, your offense types, the lengths of detention, recidivism rates. And when you examine that, how could you better serve that in terms of not arrest and detainment, but programs outside of your community? You really need to look at what type of services are available for your young people when they come into contact with the juvenile justice system. What type of services are available during and post? What partners do you have if you were to design an alternative to incarceration now and in the future? You need to gauge the level of your tribal and community leadership and support. I know oftentimes in Indian country that we think that if they do the crime, that they should do the time, that we should arrest and detain. But we really need to do a comprehensive analysis how we're utilizing all of our services in our detention center and for who those services should be targeted to. And that means educating our community around the benefits and cost savings with alternatives to incarceration, and that moving down this strategy does not mean that the community is in any risk or any less safer. So I always guide communities towards developing comprehensive communication plan, because an informed community can make the best decision on behalf of its tribal youths and families. Most importantly, I would encourage all of you to involve youth that have been involved in the juvenile justice system in talking circles and focus groups, because these young people can guide you in terms of what the real issues and the needs are for youth and families that have come into contact with the juvenile justice system. Next slide, please. I've listed about 12 to 15 no-cost or very minimal cost, low-cost, medium, and high-cost alternatives to incarceration for you. The first four, like restorative practices, healing, justice services, you know, there's always going to be a little bit of cost if we factor in people's time. But with no and low-cost alternatives such as restorative practices, healing, justice services, ceremonies, cultural programs, service learning. It takes minimal training, and you can implement these programs through volunteers. Also, with cultural arts program, you can usually partner with an existing cultural art youth-centered program within the community that you can refer court-involved youth to. Diversion programs in Indian country have incorporated restorative practices, cultural programs, there is a program, a diversion program in Red Lake, where the youth are part of that program for 3 to 6 months, and during that time, they learn how to make quilts, they make dream catchers, they go out and tap for maple syrup, they go wild ricing, and at the end of the 6 months, they put together a feast and a giveaway, and they call in everybody that was impacted by their bad decision or their offense, and they do a giveaway and they make their amends to the community. Some mid-cost programs are mentoring programs, but though once you have a training of trainers program and a mentoring program, those can become low cost. Other mid-cost programs is equine therapy, and then actually if you utilize equine therapy as an alternative to incarceration, over the course of 6 months, it can actually, the cost goes down because you're feeding 2 birds with 1 seed, because we know equine therapy is also a behavior health response for different issues that a young person might have been diagnosed with. Some of our higher costs initially are healing to wellness courts and peer and drug courts. But again, the longer a young person is involved, the cost comes down because the young person is starting to show significant progress in a shorter amount of time in one of the peer or drug courts or healing to wellness courts than they would have in being incarcerated. The Circle of Care is a great case management model that can be used pre and during and re-entry. Initially, it's higher cost, but over the 6, 9, and 12 months, it becomes a lower cost model. Higher cost options is when we need to expand educational option and vocational options for our young people. What some of the research is showing is that oftentimes our young people that are getting involved in juvenile justice, we know that they are coming to us with substance abuse issues, mental health, behavioral health issues, but oftentimes they're not finding educational success. And in developing alternatives to incarceration, it behooves us to find different options, other ways that our young people can succeed educationally and vocationally. One of the most higher cost alternatives to incarceration is out-of-home placement because of the burden that it places. There's a high cost on it. I'd also like to mention the Juvenile Detention Alternatives Initiative. While it is a higher cost, that once it is implemented over the years, it becomes more of a mid-range cost once you have staff trained and your systems in place. It's important to note that this year OJJDP just funded a tribal site, the Mississippi Band of Choctaw Indians, to begin planning and implementing a JDAI alternative within their community. Next slide, please. So when we're looking at moving away from detention and incarceration and expanding alternatives to incarceration for our young people and families, it's critically important that the values and the components encompass empowerment, and that we're looking not only at the behavior and the offense, but we're looking at the trauma, and we're looking at pathways to healing that trauma. There has to be safety, an environment of safety for our young people and our families in terms of the development of any alternatives to incarceration that we plan, and that we're creating alternatives that comprehensively weave the family, the extended family community, substance abuse and behavior health from the very beginning through post case planning, and of course cultural inclusion. I know oftentimes, because a majority of our programs are running off state and federal funding, that we don't have appropriate staffing. So it's really important to think critically in designing your ATI to ensure that you have the appropriate staffing to be successful, and training, training, training. Oftentimes we have very best practice programs, but if we don't have good training models and training models that can stand on their own and be able to sustain themselves, the best programs cannot be sustained. And of course, being able to build in a data collection plan and the evaluation plan for the alternatives to incarceration program and services that you want to develop for your youth and families. All this information that I shared for you is just a backdrop for the presenters and you. There'll be information that if you would like to know anything else that you can contact our TA Center, and I will give you resources and contacts for that. And with that many words said, I would like to introduce Mr. Joe Tanika. He's the director of the OJJDP Tribal Youth Circleback Program on the White Earth Reservation in Minnesota.
Hello, my name is Joe Tanika. I'm from the White Earth Nation, and I manage the Circleback Center on the White Earth Reservation. Our project is designed to improve the functions of tribal court by decreasing the number of alcohol and drug-related child protection and truancy cases heard annually. All child and protection truancy cases involved where children are heard in tribal court. We're also working towards decreasing the number of juvenile delinquency and felony delinquency cases within the 3 counties that the White Earth Nation resides in. The criteria to admission into the Circleback Center, and the Circleback Center is a centralized intake facility in which all tribal youth are will be coming through our doors, and we service youth ages ranging from 10 to 17 years old that need community-based continuing care, also for assessments and diagnostic assessments. One of the things that we do here is that we do chemical use assessments as well as mental health assessments. And one of the directives that we have is that our first priority is to keep them, the adolescents, in the community. So we refer to our tribal agencies first: tribal mental health, White Earth substance abuse, and our inpatient facilities, Oshki Manadu in Bemidji, Minnesota. Our referrals come from court, schools, Indian child welfare, a host of human services departments across the 3 counties that we live in. And when a child comes in through our intake process, we do the assessment, we make the recommendations, we place the adolescent in services that they need as a result of their assessment, and then we send a referral to our collaborative team, which is made up of professionals in the mental health field, tribal court, police department, substance abuse department, as well as attorneys. And from there, we decide whether or not they will be suited for our crossover program or our Juvenile Healing to Wellness Court program. And crossover program is reserved for juveniles that have been involved in petty crimes that need less supervised attention. And our Juvenile Healing to Wellness Court is designed to handle juveniles who've been convicted of drug possessions, alcohol, or theft or violence. And our Juvenile Healing to Wellness Court is more intensive, I guess you could say. We do constant UAs on our clients to make sure that they're abstaining from drugs or alcohol. We also meet on a bi-weekly basis to discuss the progress that our clients are making, all in an effort to keep our clients in the path towards sobriety. One of the things that we are doing currently is working with the schools, and we have started youth recovery support groups in the schools. We also conduct Rule 25s. Rule 25 is the chemical use assessment in Minnesota, and we're able to do those in the school. And our main priority is to meet the child where they're at. So if they don't have any transportation, we'll go pick them up. Our main focus is to get kids out of detention centers and put them in facilities or places where they can get the help. So in that respect, we will drive to detention facilities, and we have several of them in our area, about an hour away in each direction that we go. So oftentimes we'll go to these detention centers, do their chemical use assessments, and do the best that we can to have them placed within 7 working days. Oftentimes this is a timeline that we like to follow, but we can't always stick to our 7-day timeline. We run into barriers such as insurance companies, the lack of availability in beds at treatment centers, and we have applied for our NPI identification number. We also have an account with the Minnesota Department of Human Services through their consolidated chemical dependency consolidated treatment fund, in which we can access treatment dollars to pay for those treatment services. And with those monies, we can place adolescents in inpatient treatment centers as well as mental health facilities. We're also a 24/7 facility in which we can take in children needing safe and sober housing. Oftentimes during the summer and winter months, there are kids who are homeless and do not have a place to go, or they don't want to stay home because there's alcohol and drug use in the home. And what happens is that police will call us, and we come into our center, do an intake, and then we set up safe housing in a youth shelter home about an hour north of us. From there, they can stay there with it up to 7 days, and then we can make other arrangements. We also make a referral to Indian Child Protection Services. The youth that we primarily work with are ages 10 to 17. And we've been open for about a year now. We've had 52 clients with 33 current clients. We've had 8 clients complete successfully, and our program's about 6 to 8 months long. So we've had 13 clients that have been closed for non-compliance, meaning that they left treatment or they've been charged with another crime, and we're still waiting for them to be referred back to the Circle Back Center. One of the things that we are going to be implementing in July is an equine therapy program. We're going to be working with a treatment center in Bemidji, Minnesota, to offer those services. We are excited about that. We've seen how beneficial an equine program can be to Native kids, and we're hoping that we can replicate some of the work that we've seen in other nations here in Wayne, and therefore helping our youth gain more knowledge about themselves is really what we're after. And one of the things that we do is in our aftercare services is that we provide family groups as well. We don't focus on, we try not to focus totally on alcohol and drug abuse education, but we try to get the parent or the family member and the child to start talking to each other. Our main goal is communication. We want to build, to help them create healthy communication skills and sharing of ideas, maybe feelings, things like that. That's the one thing that our children are lacking, is the ability to talk with adults and safe living environments. We've been pretty lucky thus far. We've been able to receive referrals from county courts. We work closely with probation officers in the 3 counties in which our reservation resides in. We've gotten support from numerous programs on the reservation as well as off the reservation. And we're seeing some success in our Juvenile Healing to Wellness Court and also our crossover program. It's slow in coming, but we are seeing the payoff. The adolescents are really taking to this, and they're enjoying what it is that we're doing for them. And we can see it because the adolescents in our aftercare program are testing negative for substances. One of the biggest problems that we have on this reservation is those opiate use. The days, for us, the days of treating alcohol, marijuana are gone. We deal with a lot of opiate addiction here on the reservation. Now we're seeing a small number of adolescents now are moving into IV drug use. So one of the things that we're going to be pushing is education on Hep C, HIV, and the dangers of IV drug use. Also, we're going to be educating the public on opiate use and the dangers that it has, and hopefully we can kind of slow down the process, I guess you would say, of so we can get a handle on the opiate problem that we're facing. If you have any questions, that can be reached at joet@waiters.com. And with that, I'd like to move on and give it over to Judge Corey Wasaki. Okay.
Good afternoon. This is Corey Wawasik. I'm Leech Lake Tribal Court Judge, and it's really an honor to be a part of this webinar. I want to thank the co-presenters here today and everyone that's organized this, and also our attendees for taking the time to listen to our webinar this afternoon. And I want to talk about Leech Lake's Restorative Justice Program, which we call Bamanim Anishinabeg, which in Ojibwe means care for the people. And our overall goal is to address the underlying cases of crime and delinquency, and to also promote healing with our clients that we're working with. And by way of background, Minnesota is a Public Law 280 state, and the Leech Lake Tribal Court has been in a process over the years of building its capacity, and currently does not have criminal codes of its own, and is just now building its juvenile delinquency response and that sort of thing. What that's resulted in is a revolving door through the state court system, where we have tribal members and other people that live on the reservation that continually go through that state system and through probation violations and things like that are continually reincarcerated. Disproportionate minority contact is also a huge issue. In Minnesota, Native Americans make up approximately 2% of the population statewide, but in the counties that we overlap with can be as much as 80% of the youth, for instance, in out-of-home placement. And recidivism rates are extremely high. They can be, for different types of things, as much as 60%. And so in order to address those issues, Leech Lake entered into what was at the time the first joint powers agreement between the tribal court and the state courts in the 9th Judicial District. And we entered into joint powers agreements with Cass County District Court and Itasca County District Court, which are both within the 9th Judicial District, and agreed to work together and exercise our jurisdiction simultaneously towards a set of common goals. And we wanted to reduce disproportionate minority contact and reduce incarceration, out-of-home placements, things like that. So if I could have the next slide, please. And basically, we started out with adult wellness court programs. And that was our first response, and we call them wellness courts because we really do try to take a holistic approach. They're based on the 10 key components of drug courts, and we take DWI and drug offenders who have been assessed as being chemically dependent, and both felony and misdemeanor levels. And the program provides a lot of accountability, very frequent drug testing and treatment opportunities, as well as cultural services for the people that are in the tribal, in the wellness courts. And we're open to both tribal members and non-Indians who live in the county and on the reservation. And we have the tribal judge and the state judge that take the bench together to preside over these cases. We have a multidisciplinary team that includes state and tribal judges, probation, law enforcement. We have treatment providers from the tribal and the surrounding outside agencies. They're all part of our team. And referrals to the programs are generally made through the county attorney's office or defense attorneys, and we even have people that are self-referring to the program as well. And it's become a national model. It's extremely successful in terms of people coming through the program. We're able to avoid incarceration. People, by coming into the program and with the accountability that they get and the close supervision, they're able to avoid mandatory jail time, mandatory minimums that they might have on the DWI offenses. Also, people that would be presumptively committed to the Minnesota Department of Corrections, if they're enrolled in the program, then they can avoid commitment to the Department of Corrections as well. Over time, that program expanded into juvenile programming, and we added juvenile reentry and a juvenile delinquency and diversion programs. And as part of this, we expanded the work that we had on the joint jurisdiction agreement to include things like a cross-appointment order, appointing Cass County Probation to act with us and work with us in tribal court to provide probation services. As I said, we're building capacity, and that's one of the things that Leech Lake Tribal Court really didn't have, was funding to have our own probation agents to supervise delinquent juveniles, and so that really helped us to be able to provide that. We also entered into an interagency agreement internally with the Leech Lake Band of Ojibwe to be able to partner with internal organizations and agencies that we have to be able to share information and work together on things. And one of the things that the tribal court brings to this that the state court does not have is expanded jurisdiction over the parents in these cases. Where the juvenile delinquency cases are concerned, the state court really responds to the delinquent juveniles' behavior and, for instance, can't order the parents into treatment or order the parents to do certain things to help support the juveniles and to heal whole families. And so that's something that by exercising jurisdiction simultaneously, both systems bring all of their tools to the table to be able to do that.
Okay, I think Judge Wawasik lost her phone signal, so we will move forward here until she's able to get back on. So at this time, I will go ahead and let Julius Dupree from BJA is going to jump on the line here and talk about some resources that are available from BJA and OJJDP around alternatives to incarceration.
Sure, thank you, Kim. I'm going to be pretty brief here, and then
Muted.
colleague from OJJDP, Kara McDonough, is going to also speak about OJJDP's resources really quickly. We kind of separated it into grant resources and training and technical assistance. A lot of the programs that folks mentioned today, can be implemented in various ways under our grant. Some of our grant programs. Some of you may be familiar with the Coordinated Tribal Assistance Solicitation, also called CTAS. Purpose Area 3 really provides for funding to basically provide programming for a lot of the particular programs that were mentioned. And so there's a lot of flexibility there. I encourage you to go to our website and look for that source. The Coordinated Tribal Assistance Solicitation Purpose Area 4 really focuses on facility infrastructure. So if you find that you need funds to either renovate an existing facility or build a new facility for alternative purpose, that's another resource that you can look at. And again, it's the website is listed there. But what we really find is that it's definitely a lot less expensive to fund alternative facilities as opposed to more secure detention facilities. And so that our funding goes a longer way when it comes to that. We have a drug court discretionary grant program. Although it's not tribal specific, it is also inclusive of tribes. And tribes have applied for drug court funding under that to support those types of programs. We also have Justice and Mental Health Justice and Mental Health Collaboration Program. That's more mental health focused, and then you can see a BJA website listed there. But I think the wealth of information that you're going to get on our training and technical assistance resources is really going to be in the Tribal Justice and Safety Training and Technical Assistance page. And again, there's a link for that, and so you can access that at your leisure and take a look to see what our menu of services include in the way of correctional related or alternatives to incarceration related technical assistance. So with that, I'll go to Kara.
Hi, good afternoon. This is Kara McDonough, and I'm with the Office of Juvenile Justice and Delinquency Prevention. We also did list some resources. They're similar to the ones that were listed under BJA, also the Coordinated Tribal Assistance Solicitation, but our purpose areas go to support services for young people. Right now, we are in the process of, we'll be making those awards in the fall, so there's not an open solicitation in either of those purpose areas. So what I would suggest is we do have a listserv that's available. You can access it by going to ojjdp.gov, and if you click on e-news, you can subscribe to what we call JuveJust, which is a listserv that goes out really frequently, and it'll keep you updated on trainings, on any kind of open solicitations. There are tribal-specific solicitations like the ones with the links above, but tribes are also encouraged to apply for all the other funding that comes out of our office. And then we also have a really comprehensive training and technical assistance page that is at the link that you'll see up there. And you can also get on their listserv that'll send you out information about webinars and other kinds of training opportunities. And then we also listed the Tribal Justice and Safety Training and Technical Assistance page, which is a partner effort with other DOJ components. So that's all I have. Thanks.
Okay, it looks like Judge Wawasik was able to get back on. So I'm going to go backwards a little bit and let her finish up her presentation quickly. Judge?
Thank you. My sincere apologies. I never claimed to be good with the equipment. At any rate, with our juvenile programming, our clients, our target audience are youth that are 12 to 17 years old who are high risk, and our reentry clients have either been ordered to inpatient treatment or to a detention facility, and we also are working to avoid those placements to begin with. What the programming has really done is resulted in earlier discharge and youth being able to remain in the community. We really are seeing lower benefits in terms of lower recidivism rates with the joint jurisdiction programming and pooling our resources like this. With the adult wellness courts, we have a recidivism rate with one program that is 6.6%, and with our second wellness court, 16%, compared to, as I said, up to 60% recidivism rate. On our juvenile diversion program, our programming has a 23% recidivism rate versus a 36% recidivism rate for the county's regular diversion program. Other benefits we've seen is being able to leverage resources and being much more effective with what we're doing by bringing our different tools such as expanded jurisdiction that the tribal court brings to the table. And we're also able, with our approach that we take, to really use that culturally specific trauma-informed and strengths-based programming to promote trauma and really get to the root causes of what's happening and address trauma. It's also really been able to help us promote cultural understanding both between the systems and within our participants in learning more about themselves. And we've really seen a huge cost savings, especially in terms of the wellness courts. For every dollar that are invested in this program, we've seen up to anywhere from $10 to $20 in savings for that investment. And in terms of the lessons that we've learned, to really don't give up and to stay focused on common goals of trying to address those disproportionate minority contact and avoiding the incarceration and really trying to promote that healing. And we really are seeing excellent benefits. Again, if anyone has questions, I'm certainly available to answer questions. I'm sure that the contact information will be provided as part of this. And again, I apologize for my technical difficulties.
Thank you, Judge. I appreciate your input on that. We have just a few minutes left for questions. Just real quickly, I wanted to let you know about a technical assistance opportunity that's available. If you're interested in exploring some alternatives or correctional options, APPA is funded through BJA to provide some on-site technical assistance specific for tribal jurisdictions that are interested in implementing alternatives to incarceration. So following the webinar today, we will send you out some information, including a link to this project page where you can see the technical assistance request form here and request technical assistance that way. So if you have a question, at this time you can use the question feature on your participant toolbar to text that in. We did have a question that I'm going to pose to Andy, if you wouldn't mind answering this question, Andy. It was specific to whether pretrial programs would be considered a good alternative to incarceration, and whether you have experienced that how they do at the pretrial level could somehow be predictive of how they may do as, say, on community supervision.
Well, could you repeat it one more time? I had background.
Sure. The first part of the question is whether you would consider a pretrial program to be a good alternative to incarceration, and then whether you feel like that how somebody does on a pretrial diversion program would maybe be predictive of how they may do if there wasn't a pretrial program in place.
Well, of course I think the pretrial is a good alternative to incarceration, but every case is different and needs to be, I'm sorry, I'm having some technical difficulty. I think I found out why I have background noise. Every case needs to be evaluated independently. Certainly you need to take into account re-victimization, the seriousness of the crime and so forth. But all in all, these cases are being referred usually as a first-time offenders, so I would find that they would be very good alternatives to incarceration, and certainly frees up monies otherwise spent to incarcerate through proper utilization of things like electronic monitoring or the elders program that we have here at Mashantucket. And then as far as predictive, I don't like to use crystal balls, but I do find that if you are able to interact with offenders early enough and give them the appropriate prescribed dosage for treatment for behavioral therapy, I have found that that's been very good at reducing recidivism, and through the appropriate use of alternative programs has reduced recidivism. Does that answer?
Yeah, great. Thank you, Andy. So if you have a question at this time, you can use the question feature or the chat feature and chat that in. You can ask a question of any of our panelists. I'm sure they'd be happy to answer any questions. While we're waiting for maybe a question or two to come in, I just wanted to let you know about an opportunity that you will have to continue the dialogue on alternatives to incarceration using a discussion forum that was funded by the Bureau of Justice Assistance through APPA called Community Corrections Connect. There has been a discussion forum set up already in relation to this webinar. So you will be able to log on to that discussion forum and post questions, not only to the presenters for today, but also participants in the webinar today. Talk about ATIs that you're using in your community, some of the challenges, some of the successes that you've had, just as another method to share information between each other. So following today's events, we will email you information on how to connect with this discussion forum. In addition to the webinar discussion forum, there are also other discussion forums on there that you're free to participate in. This is a free service. So we hope that you all will take advantage of that. So it doesn't look like we have any other questions at this time, and it's about 4:30. So we will go ahead and conclude today's webinar. On behalf of BJA and OJJDP, we'd like to thank you for participating today. And when you log off, there will be a brief survey that we would like to ask you to complete for us. We do appreciate your participation in today's webinar, and we appreciate your feedback on the survey. So thank you, everybody, and have a great day.